Yes, Kenya. Tamu sana, yes. Supreme Court today issued their full ruling on the presidential petition. And if you go through the ruling very keenly, then from the language of the ruling and even the full ruling itself, it appears to be contradicting their ruling some few weeks ago. In this video, I want us to have a look at their full ruling briefly, after which I'll explain why I believe the Supreme Court just fell short of declaring the presidential elections null and void. Before we do that, in case you are watching us for the very first time, subscribe, give this video a like. Yes. In their full ruling today, the Supreme Court recommended 7 areas for reforms to IEBC. On corporate governance issues, number 1, Parliament should consider enhancing the statutory and regulatory framework on the separate policy and administrative remit of IEBC. 2, IEBC ought to effect formal internal guidelines that clearly delineate the policy, strategy, and oversight responsibility of the chairperson and the commissioners, and develop institutionalized guidelines on how to manage the separation of administrative and policy domains. 3, the roles of the chairperson, commissioners, and the chief executive officer, other staff, and third parties should be clearly set out in both the legislative and administrative edicts as stipulated above. 4th, on election technology. 4th, to avoid suspicion from stakeholders, unless where and when it is absolutely necessary, access to the servers supporting the transmission and storage of Forms 34A, B, and C should be restricted to IEBC staff during the election period. 5. Yes, let's go to the 5th point now. Number 5, IEBC should ensure that the servers supporting the election and those serving their internal administrative work are distinct and separate. This would then allow the court, should need arise, to carry out forensic imaging of the same without compromising and or infringing any third-party agreements. On statutory reforms, IEBC may consider simplifying and restructuring the Forms 34A and include a column that accounts for the stray ballots. In addition, it may consider having only one section for total votes, valid votes. The independent body may also find it prudent to thoroughly train its returning officers as to what constitutes valid votes per this court's decision. Yes. And then number 7. Here is the 7th, number 7 now. IEBC ought to put in place specific mechanism to allow for special voting as contemplated under Regulation 19 of the Elections General Regulation 2012. That's just a brief of the 7 areas that the Supreme Court recommended for reforms to IEBC. And if you keenly look at those areas, especially from number 2, in fact, from number 2 to number 6, the Supreme Court is actually agreeing with the petitioners. In fact, they are just cleverly, they are just admitting, but they are doing it in a very clever way. They are admitting that foreigners got access to IEBC servers. That's exactly what the Supreme Court is admitting. And when the trial was going on in the Supreme Court, when Julie Soweto exposed Jose Camago's fingerprints on IEBC servers, the Supreme Court declared that as just hot air. Yes. But from this ruling, they are in one way indirectly admitting that foreigners did access IEBC servers. And Orengo said some days later after their ruling, or rather about 1 week after their ruling, that the Supreme Court justices were his legal juniors. And basing from this kind of a ruling and from what they said, I'm in full agreement with James Orengo that some of these Supreme Court justices are indeed his legal juniors. There seems to be total confusion in the Supreme Court. They termed Julie Soweto's expose as just hot air. Now they are just admitting that foreigners did access IEBC servers. They are just trying to do it very cleverly, indirectly. And then if you look at also an area here, where they are saying IEBC, the chairperson of the IEBC ought to effect formal internal guidelines that clearly delineate the policy strategy and oversight responsibility of the chairperson and the commissioners, and develop institutionalized guidelines on how to manage the separation of administrative and policy domains. I'm seeing that as also an admission that Supreme Court found fault on how Wafula Chebukati managed the elections. It comes out clearly that Chebukati single-handedly managed the presidential election. The Supreme Court is just being shy. They don't just want to pinpoint and to hit the nail on the head on exactly where the problem was. And I don't think it's just about laws being enacted or reforms. The laws are already there. They're enough for any competent court to actually take action using those laws. In fact, in 2017, the Court of Appeal found the ruling very clear, or rather made the ruling clearly that it's not all about the chairperson of IEBC. There is a reason why framers of the Constitution placed 7 commissioners. Common sense should be common that the 7 commissioners are there so that in the event they cannot come up with a unanimous decision, then the decision has to be made by voting, where the majority vote becomes the position of the commission. That should be even very clear to even a high school dropout. There is a reason why commissioners are 7. No need of these so many laws and reforms. Laws are already there. What is needed are men and women of competence, men and women of integrity, to sit at the Supreme Court to interpret the law as it is, instead of looking for excuses for more reforms. Laws are there. No need of any reforms, in my honest opinion. What is needed are men and women of competence, of integrity, who will make their ruling based on law and evidence, not based on some intervention from God or some intervention from supernatural power. From this ruling, ladies and gentlemen, I'm seeing a Supreme Court that is just falling short of declaring the presidential elections null and void. They are just afraid, or rather they were just afraid to say so. But from this full ruling, it's clear they had no reason of upholding William Ruto's election. This comes out very, very clearly. And even if you go through the entire ruling, there is no concrete reason they are giving for upholding William Ruto's election. Because even the turnout itself, they are not even sure of what was the turnout. And I believe it's on the turnout that you can actually get the total votes cast and the valid votes. They are not very sure on what was the turnout. As I conclude, the best thing now for the Supreme Court to do is for the 7 justices to resign. Kenyans have lost hope and trust in them. And in the foreseeable future, no Kenyan will get the guts or that courage to challenge any presidential election at the Supreme Court. Martha Koome and her bench actually took Kenyans years back during the Kanu days. And even though they are trying to redeem their image, the damage is already done. Yes. Let me stop it there. In case you are watching us for the very first time, subscribe, give this video a like. And to our fans and subscribers here, I'm very much humbled, very grateful for the kind of support you are giving me here. Any other person who wants to have a chat or a discussion or to support this channel, I've pinned my number on the comment section. Contact me through the number, or you can channel any support or contribution to the number. Let's meet in our next analysis.